That's fine. That's just life. We're going to always want to tell one another what we should and shouldn't do about our other people, our neighbors' kids. But they don't have the power. We don't have the power. The government has enormous power.
Hey everybody, Alex Newman here with Conversations That Matter. Welcome to another episode. Today we have two very special guests. We have David Delugas. He is with ParentsUSA. They litigate around the country and get involved in cases involving parental rights to try to protect the rights of parents to guide and direct the upbringing of their children. We also have with us today Professor David Pimentel. He is a law professor in Idaho. They're both involved in a case that has really, I think, national implications and very serious implications for parental rights. It involves a family that moved away from California to Idaho, in part at least to protect them from grandparents who were described as toxic. And so this raises a number of issues. Idaho has got a law on the books that allows quote unquote visitation rights for grandparents under certain circumstances, and other states have similar issues. David, let's start with you, David Delugas. Give us a little bit of background on this case. Give us just some outline and why is this important for people across the country to understand?
Well, every parent in America should be concerned. Most states have, if not every state has, a grandparent visitation or close family member visitation statute. Mind you, it doesn't provide that these relatives have rights. It just provides a mechanism by which people can go to court and get a court order. Keep in mind, court orders are enforced by our police departments and such, or contempt power. So it's meaningful. So in this particular case, we don't represent the parents. We are the term friends of the court, amicus curiae, who filed a brief with the Idaho Supreme Court supporting the position of the parents who viewed it this way. We are fit parents, and a trial court found them to be fit. We are making decisions about our children that we think are best for our kids. And we believe that these parents, grandparents, are so toxic that we just have to protect our family from them. And incidentally, in this particular case, the trial court agreed with the parents and said, yes, these grandparents are out of control. They don't respect your boundaries as parents. They do things to undermine you. But I, as the trial judge, am finding it in the best interest of the children to award these grandparents some contact rights and terms, provided the grandparents go to a certain amount of counseling to cure or correct some of their issues. Now, just on the surface, that should make people all scrunch up their faces and go, really? So that, in essence, is where we are. The parents want to be able to control their own children's destiny in their lives, and the grandparents who are well-heeled and can afford to continue to do this keep pushing on. One of the issues that we brought up in our amicus brief is not every parent can fight back. Not every parent can afford the attorney's fees to do that. So most capitulate, most give in because they have no other alternative.
Wow. Fascinating. Professor Pimentel, you're at the University of Idaho, and you've taken an interest in this case. I understand you've even filed something in this case. Tell us, the Supreme Court, before we started going on air, we talked a little bit about some of the Supreme Court cases at issue here. To what extent do parents have the absolute right to direct the upbringing of their children, and when is the state authorized to intervene? And why are you concerned about this particular statute in Idaho and similar statutes in other states that purport to give these, I guess not quite rights, David Delugas said, but authorities to grandparents and other relatives to intervene in the lives of families?
Well, I mean, that's a great question. There have been a series of Supreme Court cases over the last century relating to parents' rights to make decisions for their children. There are early cases involving parents, Amish parents who wanted to keep their children out of public schools, and laws that required them to send them. And the Supreme Court has said, you know what, parents should be able to make these judgment calls. I mean, these are core values. These are protecting important interests in the family. But in 2000, we had a case that came out of the state of Washington, Troxel versus Granville, I think it was, where the Supreme Court that involved actually grandparent access to their children, to their grandchildren, and the parents didn't want that access. And the judge in Washington allowed such access. It went all the way to the U.S. Supreme Court, and the Supreme Court said, no, this is a fundamental liberty interest of parents if they are fit parents. And unfit parents, that's a legal definition. I mean, if the parents are drug addicts, if the parents aren't providing for their children, if the parents are actually incarcerated, they can't provide. They're not fit parents under those circumstances. And of course, the court has to intervene. If the children are being abused, then the court has to intervene in order to protect the children. But this is kind of a slippery slope once you start saying that it's okay for the court to intervene in families for the best interest of the children. This has opened the door in cases such as this one for trial judges essentially to second guess parenting decisions. Well, you may think it's good for your parent, for your children there was actually one case that arose where a teenager and his parents were in serious conflict because the parents wanted the teenager to go to church and like 3 times a week. And it ended up in front of a judge, and the judge said, I think 1 time a week is enough. And the parents are saying, we think maybe we should be able to make a decision about what's best for our child and not have the state second guessing us. And so that's really what's at stake here. I published an article that talked about this best interest of the child standard, because who can argue with that? We should all be acting in the best interest of children. But the way the law is written, I think very wisely, the constitutional rights say that writ large, what is best for the children, the best interest of the children, is to let their parents decide. The parents know these kids like the state can never know these kids. The parents love these kids like the state can never love these kids. And so to allow parents to be second guessed, fit parents to be second guessed, is really a startling intrusion into the family and into some really basic and cherished rights, I think, that we have as Americans.
Yeah, Alex, may I just dovetail off of that? As David says it, each of us may disagree with those parents who wanted their kids to go to church 3 times a week. We may disagree, but you know what? None of us has the power that the government has, because they have contempt powers, they have police powers. So family members can disagree. They can tell you, you shouldn't let your kid play football, or you should make sure your kids eat this or that. That's fine. That's just life. We're going to always want to tell one another what we should and shouldn't do about our other people, our neighbors' kids. But they don't have the power. We don't have the power. The government has enormous power. And that's why we should be concerned, and why we should follow, which is what ParentsUSA does, follow what the U.S. Supreme Court has said on this issue.
Yep. Well, on this topic, it reminds me of something. I did a lot of work years ago on the UN Convention on the Rights of the Child. And under this international treaty, the United States has not signed on, and the UN loves to beat us over the head with that, because I guess we're the only ones, along with Somalia, that didn't. But under the text of this international agreement, it actually includes in there that standard, the best interest of the child. And it's not spelled out, but it's implied that the best interest of the child will be determined by the government. We actually saw the Scottish Parliament pass a law. This was a few years ago, and I wrote an article about it for the New American, naming what they called a named person to every child when that child is born, to kind of oversee and make sure that the best interests of the child were being pursued by the parents, kind of like a government intrusion direct into the family. Is it an exaggeration? Are these just overblown fears to suggest that once this camel's nose is under the tent, we could find ourselves being, as parents, second guessed by some bureaucrat, some social worker, some judge? And how do we resist that danger? I mean, should we be fighting in the courts, in the legislatures, all of the above, none of the above, in the court of public opinion? So is that a real threat, and how do we deal with it?
I absolutely, it's a real threat. And yes, we should apply all of those pressures. The problem is, as Professor Pimentel laid out, anytime you say, well, it's for the children, who's going to argue with that? Who's going to say, no, we can't do that. It's for the children. So legislatures, governors, they get carried away because it gets voters. People don't really examine what the law is saying or does. I mean, we can even just go into child abuse statistics and say the way we handle it is so inefficient, ineffective, that we're wasting money and not protecting children as we should protect them. But yes, that all of what you just said is absolutely true. And it's absolutely a concern. And I thank you for bringing some attention to this issue, because as this case is about grandparents intruding on a family, other cases are about everything else. And yet, let's make sure everybody's clear. Children should be protected, and states do have a compelling governmental interest that allows override of constitutional rights, if necessary, to protect the children. But that's rarely as often the case as is portrayed.
Yeah. Professor Pimentel, I want, on the flip side of this, I'm sure there's people watching this right now who are thinking, hey, I'm a grandparent, and my child and my son-in-law or daughter-in-law, they're really going off the rails. They're talking about, I don't know, depending on where they are, my kids are talking about putting my grandkids on puberty blockers or hormones to, become a new gender, or on the flip side, hey, my kids are brainwashing my grandchild to be a fundamentalist Christian, whatever. Should there be any mechanism for other family members to get involved, and to what extent should that be tolerated in a free society?
Well, I mean, that's the big question, and that's a tough question. There are no easy answers here, and I've been accused of taking the side of child abusers because I have suggested that the government's right to intrude should be limited in some ways, and so drawing the lines are very, very hard, and we do want to protect children, and this ultimately comes down to being a part of just a battle zone in the culture war we have in America about whether a generation ago it was about teenagers who want abortions, and now, of course, the transgender rights issues have become a serious battleground, and our society is going to have to sort its way through that. But I don't think there are easy answers there, and I certainly wouldn't venture to offer one here. I do actually, on an unrelated moment, I just need to clarify. I did not, in fact, file an amicus brief in this case. I assisted David with his brief. I had sought amicus status, and the court wouldn't allow me to come in my own capacity, but I did work with David on his brief in this case. So just to set the record straight.
Okay, fantastic. Well, I appreciate that. Thank you, Professor. Where can people follow this case? David Delugas, what's the best website for people to stay up on the important work you guys are doing? And is there some way for the public to get involved? Maybe not in this particular case, but more broadly?
Well, certainly, if anybody wants to visit our website or visit us on social media, we're ParentsUSA, ParentsUSA.org, and we're on all the major social media sites, and we'll be posting updates on this case. Do not expect a decision from the Idaho Supreme Court until mid to late summer, if not fall. But all the briefing has been done, and we're just waiting for a decision from the court. And doesn't that just sound odd? Parents are waiting for a decision from the court about how to live their life within their family when their kids are perfectly safe. And as the trial court here found, very happy. They're doing fine.
Wow. What a story. Well, thank you both so much for speaking out, for your involvement in this. And thank you very much for spending some time with us and sharing your insight. We really appreciate it.
Thanks so much, Alex.
All right, folks. That was David Delugas with ParentsUSA and Professor David Pimentel at the University of Idaho, a law professor there. Another incredible case. We actually had David Delugas not too long ago about a mother in Georgia who was arrested for leaving her children at home unattended. I think the daughter was 14. So, folks, they're involved in some critically important cases that if you're a parent, have a real bearing on your future and your rights as a parent to direct the upbringing of your children. So stay tuned to this, folks. These issues are so important. As the question goes, that new movie that just came out, whose children are they anyway? Do they belong to the government or not? And as a society, we're increasingly having to wrestle with this question. So I want to thank you for tuning in. I'm Alex Newman. This is Conversations That Matter for the New American Magazine. Until next time, God bless you all.